All right, so we're picking up on part 2 of criminal law. This is from chapter 8, and we're going to look at for this part of the lecture. We're going to talk about the crimes that are committed against people, crimes that they're all really obviously committed against people, but and ultimately society as well. But specific crimes against a person, crimes against business, and then we'll look at also a definition of white-collar crimes. And let me see, I'm looking through my notes here too, and some other types of inchoate crimes or incomplete crimes, and then we'll get to defenses, and finally after defenses we will be looking at constitutional aspects of criminal law. Okay, so crimes against the person, the one that very frequently just comes up, the first thing that comes to mind when somebody thinks of crime, they think of something like murder, and murder under criminal code in virtually every state in the country, and federal law basically requires that there has to be some malice involved. Malice aforethought is often the language you hear. It's in your textbook too, that basically someone kills someone with the intent to kill. So we're talking specific intent. They intended to kill someone and they did kill them. That's cold-blooded murder, we say, right? Or sometimes it may be that someone acts in a way that unreasonably results in someone's death, and so if you push someone out of a 5th floor window, when you're doing this that it's pretty certain that someone's going to die. So in that case, we would consider that to be murder too. So it's basically unlawful killing of a human being, right? Now we get into some gray areas here. This whole issue with abortion, and some people obviously are in protesting abortion. We'll talk about this as killing a human being. Federal law, recent federal law, where there's still some challenges to Roe versus Wade that have come up through the Supreme Court, U.S. Supreme Court, and as it stands, typically the term fetus, when we're talking about a fetus, it is not considered to be a human being. Although, interestingly enough, some federal laws, I mentioned here in the slide, some federal cases that have taken place where someone purposefully harms a person who's pregnant and unknowingly, this is going to have an impact on the fetus. If the fetus dies, then it can be considered to be murder, even though the technical definition, since we allow for abortion, doesn't consider the fetus to be a human being. The California law, I believe there's a California case where this has happened. If somebody intends to harm the fetus and ends up with a death of the fetus, then that's been considered to be murder as well. So typically murder is unlawful because the statute says so, killing of another human being. Okay, so and then in various jurisdictions there are all sorts of degrees, just like we talk about with other crimes, felony crimes. There could be degrees, even misdemeanors. There's a distinguishing between different types as to whether a more severe sentence should happen in each. When we're talking about first-degree murder, first-degree murder typically is a capital offense, so that means the death penalty to the defendant, or life in prison without a chance of parole. We're seeing those cases, and those are all sorts of torture, poisoning to kill someone. You ambush, you sneak up on someone and kill them. It could be you're engaging in some other dangerous felony, robbery or murder, or robbery or rape or something like that, and then someone dies. Or you may have premeditated and planned this whole thing out. First degree is more serious in those types of cases, and so the penalty is going to be more severe. Death penalty could happen with it if the jurisdiction allows for the death penalty, or life in prison without parole, first degree. Now, you have some jurisdictions like the state of New York. I'm not sure if it's still this way, but when I was in law school there, first-degree murder only happened was only granted against the defendant if the defendant killed a police officer, a judge, a politician, someone at the highest level of the law. And the reasoning behind that, you and I, if we were killed, we would have gotten second degree. The defendant would have gotten second degree or something different, unless you came into one of those categories. And the reasoning behind it was, this person who's been killed, who's a politician or a judge or a police officer, you're having the utmost disrespect for the law, and in that case, you have that much disrespect for society, and so in those cases, it should be first degree. I'm not aware of any other state in the country at the time that does based on that sort of classification, but New York used to be that way. I should probably check on the current law, but that was the case for first-degree murder there. So obviously anything less than these types of cases, you can have second degree, third degree, depending on what's there. Some different determinations of voluntary or involuntary manslaughter is called, which is a lower level of offense. And so I'm not going to go through all the degrees, but that's what you would see with that in murder. Another aspect of murder cases is what's called the felony murder rule. And in this type of situation, the parties agree to commit some inherently dangerous felony, and they don't intend to kill anybody, but guess what? Someone dies. And so here's an example for you. 3 people go in to rob are going to a 7-Eleven to rob it. C is the lookout driver in the car to look out to see if the police or anybody else comes along. A and B go inside. They have a gun, and they don't intend to kill anybody, but A shoots, the gun goes off accidentally, and A shoots the cashier and kills the cashier. Under the law of what's called felony murder rule, since they were engaging, all 3 were involved in this inherently dangerous felony that they're committing. If someone dies, anyone dies in the act of that, all 3 of them will be legally liable under the felony murder rule for the same level of crime. Let's say instead of A or B having the gun go off accidentally, the police arrive, and they go to shoot A or B who have a gun. C is still lookout in the car. The police miss A or B, and the police kill the cashier. Guess what? A, B, and C will all still be liable for that death of the cashier, because what they did, they're involved in something that was reasonably inherently dangerous activity. It's quite likely that someone could get killed in that types of situation, so they would be held liable under that theory, felony murder rule. Okay. All right. Less offensive or less I guess intensive case could be here. It would be under assault, and I'm going to break this down again. These are by the elements. Typically, there has to be some kind of threat that's involved, and it typically has to be immediate. So this is not, somebody threatens you and says, "I'm going to meet me at 3 o'clock and I'm going to beat you up this afternoon." You have to be, there's could be potentially immediate contact with you. So somebody has a baseball bat and they're aiming it, they're going to swing at your head, and you are fearful. There's a threat of immediate harm or contact, or it could be somebody does anything that a reasonable person would fear imminent harm. So a 255-pound, 6'5" guy comes up to a woman who's 5 feet tall, maybe weighs 100 pounds, and he says, "Give me your purse, or I'll bash you," or something. She does not. Excuse me. I'm going to cough in there. She does not have to have any contact from this man to feel threatened. He's a big guy, she's petite, and so then she feels threatened, and so in that case there's assault. No physical contact is necessary. That's all that needs. It's a reasonable apprehension that she would have that she's going to get harmed by this person. Now, suppose instead she's a 5th degree black belt or something, and this guy says this to her, and she says, "Okay, bring it on. I'm ready to knock your block off, buddy." In that case, did she really feel threatened or not? It's enough. The jury would have to think about it. But if she, he walks away, and he's afraid that she, gets in a good karate stance, and he's afraid that he's going to get clobbered, and he walks away or runs away. Has he still committed assault? Arguably yes, but then if she doesn't really feel threatened, if she's laughing at him, she might, the defendant might argue later on that he wasn't really a threat to her. All right. So again, no contact necessary for assault. Just somebody has to reasonably feel that they're going to be harmed, and it's got to be immediate, not later on. Battery is the next piece. Usually you hear assault and battery together. Battery is technically really a completed assault. So I use the idea, here's a duress. Think of the actual battery. If I throw the battery at you and I miss, it was reasonable that you were afraid of immediate contact. So clearly I committed assault. If you see me throwing it at you, or I warn you, or I say something to you, I'm going to do this unless, and I throw the battery at you and I miss, that's assault. But if I actually hit you, I not only threatened you, but I also committed battery. So this was a Detroit Pistons game, I think, a while back, and someone in the stands was saying something, yelling at this guy, and so while he could argue that this person is threatening him from the stands, and he feels assaulted, when he gets up, runs up in the stands and starts swinging at someone, he's not only committing assault now, but then when he has physical contact, he's also committing battery. So here, basically for battery, you have unauthorized and harmful or offensive physical contact. So if someone has to not give you permission to do this, it has to be harmful in some way. It's not authorized, obviously, and when there's physical contact, then you're at the point of battery. Okay. Next crime against person we're talking about is kidnapping, and in this case, I'll break it down again. Typically what we're going to say is it's unlawful because, again, the statute says so, the criminal codes, but it requires seizure and transport of a victim, and it has to be against his or her will. So basically, here's the case. I think this kid, it was a case in California, I believe. The kid was like about maybe 11 or 12 years old. He was a younger kid. Saw a car running outside of a 7-Eleven kind of a place. Got into this car and could barely probably even see over the dashboard, but got in the car and took off with it. Riding down the street, and all of a sudden he hears this baby crying in the back seat. What's he done? Well, he's committed kidnapping because he sees someone and he's transporting that person, and there's a victim in the back seat. It's this baby. While it wasn't against necessarily that it could be vocalized, it was against his or her will. Clearly, the parents wouldn't be too happy about having their child carried away this way, and so with kidnapping, this, even though it's a minor, the kid, the defendant, is going to be in trouble for this. Under the law, would be considered to be kidnapping. Now, if this was somebody and they were doing this and they were trying to get the car wasn't started, but they got, somehow the keys were left in the car, and they jumped in the car at the 7-Eleven, and they're backing up, but they don't even get the car started. Maybe it's in gear, but it just it's coasting back as they get the brake release or something. Did this person transport someone? It might be debatable. Say the police arrived right at that moment. Yes, there's seizure. Yes, there's a victim, and it's not their, it's against their will to move anywhere. But if a car hasn't moved, did they really transport someone? We might talk about what's considered to be false imprisonment. Maybe in that case, you're familiar with this term from our trial, in our civil trial with the Walmart case and Nancy Bath and David Hedge. Basically, when someone isn't free to leave, they're placed in a room and they are detained and they can't leave. We consider that to be false imprisonment. There might be a crime in this case, type of case too, if someone did this with a weapon or something and unlawfully did it. We could look at the crime side, or we could look at the tort side. But false imprisonment, you're not transporting anyone, you're just keeping them from being able to leave. If they reasonably feel they were restrained and unable to leave, we might be able to argue that, both on the criminal side and the tort side with false imprisonment. Kidnapping typically requires someone transports the victim. And again, we usually see these in the police shows and all that, the kidnapping, there's a ransom and all that, but that's not necessary. This is what's required under most common law jurisdictions, right? All right, robbery. Robbery, basically, you in this type of situation, people take money from the defendant takes money from someone, or they take their personal property from them, and they do this. They took the personal property from the person, or it's in the person's immediate presence. So they also do this with some force or some fear involved. So there may or may not be a weapon. If there's a weapon, a gun like this guy's has here in a bank robbery, then there's an enhanced, a more serious sentence. Somebody does this with a gun or a knife or something like that. But typically, all someone has to do, I gave you the example of the big guy with the petite woman, and he threatens her with assault, threatened to harm her if she didn't give him her purse. If there's an assault that's there, if she hands over her purse, he's obviously made a threat. There's force or fear involved in it, and he's taking her personal property. He could also be charged with robbery. All right, so basically that's what we're looking at. And again, if there's a weapon involved, then it's more likely to be a more serious offense that way. Okay. Next one here, and I guess this says, again, crimes affecting business, but these obviously, in the businesses, we're talking about individuals, so it's crimes affecting people too. It relates to both. In the case of burglary, it's unauthorized entry of a building, and today we have to, I'll clarify that for a second, entry of a building to commit theft or commit some other felony like arson, to burn the building down. It used to be that burglary under Old English common law was only involved entry into breaking, so having some way to break a lock or break a window or do something. Breaking and entering the building was home, and it had to be done in the evening when it was dark. So the thinking was there's more likely of something very dangerous or even death to happen if someone comes into someone's home at nighttime, and so burglarizing was typically and people did it in the evening in the dark so that they wouldn't be seen doing this type of thing. So burglary in the Old English common law required entry of a home, and it had to happen in the evening. Today, burglary is any unauthorized entry. So you could be an employee that is fired, and you decide you still have your I don't know, security guard card, your security card to get into the electronic card to get into an entrance. You go in and you go back to your desk and take a bunch of things. Your entry is no longer authorized. You're in a building, this is true, and then you've committed theft, potentially. Even if you say you're getting your own stuff, you're trespassing, certainly, and so burglary potentially could happen with you in that case. A building is defined not necessarily as a building now too. It also could be, burglary is unauthorized entry of, it could be someone's motorhome, it could be someone's warehouse, it could be a boat that you own. So technically personal property could also be involved in this. And again, to commit theft or to commit the felony, to murder someone in there or to commit some other crime, you're going to get burglary in that process. So I just have this with the kitty is guarding the house here. You've got the gun, somebody's coming in armed, and then there's a person. The traditional view of this is someone burglarizing, coming in at nighttime with a flashlight and all that. And again, that's not required under the law today, but burglary, that's what you have for burglary. Okay. Next one here is theft, and theft, again, here what's significant in the difference between this and robbery is there's no force or fear. Theft is just unlawful because the statute, again, says so, and it's taking of somebody else's personal property. So you take someone's backpack, you take someone's car. In most jurisdictions, depending on the value is how we look at this now. If someone steals a couple of golf clubs or something from a sporting goods store, it may be a misdemeanor, and because the dollar value is less. If they steal a car, here's the video game Grand Theft Auto. If somebody steals a car, the value is higher, and so you'll get grand theft charge is going to be a felony and a larger penalty that goes with it. Okay. In many jurisdictions, now if you go back east, you're going to see this term, and I'm not even sure if it's in your textbook, honestly, but it's an old English common law term, larceny, and it basically means the same thing as we were on the last slide. It just basically means theft. It's taking a personal property, and you don't have any force or fear that's involved. So in many jurisdictions, like I say, back east, if you go back, I think Connecticut and New England, a lot of states, they use larceny instead of theft as the terminology they have. It's basically the same thing. You might have some of those jurisdictions who also have cases where they call larceny by trick, and this is somebody does some trickery, some the shell game. They're trying to do something with you here, bet some money on this, and it's a rigged game, and so they're taking your money, your property, and they're doing it by some fraud or some scheme to do that. And so in many jurisdictions today, we just call this criminal fraud, but in the case of the states or jurisdictions that have larceny as their theft definition, they may call it larceny by trick. Right? This next one is interesting because a lot of people think that it's never going to happen to them when they do this, that they could get caught for this, but it does, especially in our eBay world and our technology world. People think they're immune to this, but receipt of stolen property is a crime, and the test is this: or you absolutely should have known that the property that you've received is stolen. And factually, the juries are going to listen to the evidence. If you get caught for this, they're going to look at the evidence, and the facts are going to be the ultimate determining aspect of whether you get a worse penalty or not. So here, to picture somebody, I'm in the bicycle world, but picture this is a really nice bike. It's probably worth well over $1,000, maybe $1,500. Somebody is, I don't know, I'm just going to throw it out there. Pioneer Square, you're down there late on a Saturday night or something, and somebody comes out of an alley and they've got this brand new bike. It's even got the warranty on it and all this, and they say, hey, $20 and this is yours. And you go, wow, yeah, great, that's a great bike. Okay, here, $20. You walk around the corner, there's a police officer standing there, and they've had a report of a sporting goods store getting broken into. And they say, where'd you get the bike? You're like, well, the guy just sold it to me. Well, let's see, how much he sold it to you for? $20. Well, let's see, that's a bike that's been reported stolen. You've received stolen property because very clearly you should have known this bike was worth more than $20. Chances are you're going to get charged with a crime, receipt of stolen property, for doing that. It may be very well that if you testified as to who the person was that sold it to you, and you turned as a witness, you might not get charged with anything formally, but you never know. The crime, you've definitely committed the crime under criminal law. Now, if somebody came up to you with a bike like this, an old beaten up bike, and they said, $20, you might actually say, pay me $20 and I'll take it from you. Obviously, like I said, the facts are the key in these types of situations, and so you need to have that spelled out. Okay. The next crime here is arson, and it requires some malice, some intent of harm. You willfully intend to do this. You want to do this on purpose, and you burn real property. Real property being something that's fixed to the land. It's the house. It's a warehouse. It's an office building, something like that. Or it could be personal property nowadays too. It could be a truck. It could be a motorhome. It could be a boat. But basically, you willfully, intentionally go and harm by way of fire. You burn someone's vehicle or their home, and then we consider that to be arson, or their business, obviously. Another crime that's frequent in business, we see probably more so these days, is forgery. And forgery requires that you, by fraud or deception, falsify a written document. So you alter or you make from scratch a written document that ultimately affects somebody else's legal liability. So you can do this by altering your paycheck and adding a zero on it. You can do this by writing a check to yourself from your employer. You can do this by 101 ways you can imagine, falsifying IDs so that people look to be older than they are, or changing the year or things like that on it, so you could buy alcohol when you're younger than the legal limit. Anything, again, you alter or falsify a document is considered to be forgery. Right. This next slide I probably need to correct, I think, with the language I have on it. But extortion is one way that things happen in businesses, and basically you're using force or fear as a way of unlawfully obtaining money from someone. And so I use this is probably the wrong example. Give me your lunch money or I'll beat you up. Probably the better way is to look at it like this. This is an actual, I think, a phishing, they call it technological phishing or something, thing that basically warns a business that they are going to lose tons of money unless they send by wire transfer $10,000 to this particular threatening entity, whoever it is. This was it says extortion note to ProTX. It was an online payment processing firm. So the extortion is saying you're unlawfully demanding money, and you have a threat that's behind it, essentially, and the business either comes up with the money that you're asking, or they're going to suffer something by your act. And so that's what we're talking about with extortion. It's similar, although probably a little bit different here when we're looking at cases of blackmail. Blackmail, again, is unlawfully taking somebody's money by way of a threat. Most often, and I mentioned here, it's between private parties. Most often, not always, blackmail is done where the parties know each other, right? And so somehow someone makes a threat. They've seen their boss at lunch or dinner with someone other than their spouse, and then they want to use that as a way to obtain money. So they say, I'll tell your spouse that you were cheating on them if you don't give me X amount of money. It's blackmail. Typically, like I said, the parties know each other in some way. There are all sorts of celebrities where you hear this, where someone's accused of having parented a child outside of their marriage or something, and the party is trying to get them to give them money. It's blackmail, and that's typically how we do that. There's a threat. It's not necessarily the same as what we see with extortion. When we look at the common law, the distinction with extortion under old common law typically was that public officials had to be involved when you're looking at extortion. So a politician somehow is being told by, has some reasonable fear of force being waged against them, and so then they provide money to someone. That would typically be extortion. But blackmail and extortion are pretty close in practice, but the common law distinction was made with public officials for extortion. Something that's really unfortunately too common these days. The first one here, bad check situations. Often people will do this because they get paid on Friday, but their rent is due Monday, so they write a check, and they don't have money in the account when they're writing the check, or it's harder to do this now because of our technological world. You can go to a retail place and you write a check. If your check is no good, there's electronic ways that they can check on this, But essentially, if you write a check, and you are writing by that check, you are saying you have that money at that moment to cover the check, not a week later or not on Friday to pay your rent. And so we consider this floating checks, and we do this most often. There's legislation in most jurisdictions across the country. It could be a misdemeanor, it could be a felony if the value is high enough. But if you're writing checks and you don't have money when you write them, you're committing fraud too in the process. Even if you're anticipating money coming in at a certain point in time, if you don't have the money, you're creating a fraudulent document. There's legislation that makes that a crime, and you could be in trouble for that, obviously. Credit card crimes are the other one here, and so using someone else's credit card or credit card number, you're essentially committing fraud because you're representing that you have that number. It's your valid number, and it's not. And obviously, there's depending on the value, can also be a felony. Credit cards, when you do this across state lines, if you're doing this via the internet, you somehow use someone's number falsely, you're committing a federal crime in that case, and so there can be felony conviction that could go along with that. Okay, white-collar crimes are a whole type of crime that, just by definition here, at the end of the day, there's not a bloody body laying somewhere. A white-collar crime is essentially where someone is conniving. They do some sneaky way to obtain money, and there's, like I said again, there's no violent crime involved in this, although you could consider it to be as bad as a violent crime when people lose all their retirement money or something like that. In other cases, it's not so much that, but it's things like embezzlement, where basically this is an employee who steals from their employer. And again, some sneaky way that you do this. If any of you have seen the movie Office Space, is kind of a silly comedy. In that movie, the employees are tired of their company. They come up with some scheme to electronically. They create an account and they electronically add They think they're adding like 0.001. This tiny cent, not even a portion of 1 cent per transaction that takes place with this business, and it's depositing in their account. They screw up on the decimal points, and it ends up throwing a ton of money in their account overnight. And so either way, they're embezzling from their company. Theft from those employees, from the employers, embezzlement, and it's a white-collar crime. And again, depending on the value and the level of deception, you're going to get a more serious sentence with it. Criminal fraud, I've already mentioned. Taking somebody's property through deception, some false way that you get them to part with their money. this can be it happens in different ways. It could be happening over the U.S. mail. It could happen, they say, wire fraud. We have less of this nowadays, but still people use like Western Union and different forms of, the old telegram type of thing. People wire money or bank wiring of money, and it's done fraudulently. You use the internet to do this. Those are typically, since they involve the U.S. government or the international or global or cross-country, cross-state bounds, there are going to be federal cases, and there are going to be more serious penalties that go along with that, felony cases. Bribery, you can have different types of, commercial bribery in a commercial setting where somebody is bidding for a project to, build a local shopping center or something, and they pay off someone to do this. And if it's paying, you might be bribery or paying a public official to do something. It's a crime, and again, it comes under this definition of white-collar crime, paying money to someone that they otherwise wouldn't be appropriately receiving those funds, and then they are doing you a favor that way is clearly criminal, and there's a penalty that would go with that as well. Something else that's we're seeing a lot of, and there's some federal law about this too, and actually state law, depends on the jurisdiction you're looking at, but there's this term called money laundering, and basically in and of itself it's a crime to try to hide money that you've gotten from an illegal transaction. So you're basically transferring money, or you're putting it in something that looks legitimate. You might buy a restaurant, but all the money that you did to buy the restaurant or to refurbish everything in the restaurant was all gotten because you're involved in drug dealing. It looks legitimate, the restaurant is there, or the restaurant already existed, and now you've given all new furniture and a whole new interior to it, but it's all paid for by some illegal organized crime or some other thing that's involved there. Not only are you guilty of the underlying crime, but you can also be guilty of the white-collar crime of money laundering, because you're trying to hide funds somehow to make them look more legitimate, and there's the penalty that goes with that. So this next slide I'm actually going to skip over. Let me even think it's in your textbook, but if you want to dig more into it, feel free. This whole it was aimed at primarily originally at organized crime, but there's a whole federal law. It's called RICO, Racketeering, Influenced, and Corrupt Organizations Act, and it's a federal crime that basically goes after businesses, and businesses can forfeit their property and all sorts of things if they come under the terms of this particular federal legislation. Okay. Now the next group of crimes, we talked about all these different types of crimes, and then I'm going to talk about what are called inchoate crimes. And inchoate crimes, one way to remember that, it's spelled inchoate. That's how you would look at it if you're going to phonetically pronounce it. But inchoate crimes are essentially incomplete crimes. You want to do something, you're trying to commit something, you intend this act, but you're not totally successful. So in this case, maybe they get together to make a meeting to do something illegal, and they're not successful at the actual illegal act, the crime, but they're still guilty of conspiracy. So they've conspired. They got together to do that. That's enough. It's an incomplete crime. And so conspiracy is one of those. So two or more people get together to commit a crime, and they do something that steps over the just talking about it stage to something that makes it more real. So here's an example. You have two securities brokers. They deal with the stock exchange market, and they make some agreement. They're sitting at lunch somewhere in some restaurant. They think nobody can hear them. They make an agreement to commit securities fraud, and then they go back and they actually gather a list of who their victims are. They get some false statements that are gathered, and they meet again in the restaurant to discuss it. This time somebody overhears them, and it turns out it's a federal investigator, and they haven't been successful with taking the money from these victims, but they've planned it. That's enough, and guess what? They're going to face the crime of criminal conspiracy. Now, obviously, it's not as serious as if they had actually conspired and been successful at taking the money from these potential victims, but they're still going to be charged with conspiracy. If they were successful, they're going to be charged with the fraud and deceit, the criminal fraud that they did against the victims, and they're going to be subject to the crime of criminal conspiracy as well. Okay. All right, another inchoate crime. So here you have the Wall Street people, the money going out there, and that's the end result of the people doing that, right? So here, another inchoate crime is what's called attempt. And so in this case, basically what you do is you shoot and you miss someone. So this is a real case that happened in Florida a few years back. A politician was going on election day, walking up to to go vote in the voters' booth. Of course, he was going to vote for himself. It's typically, they make a big newsworthy event of it. The politician's going to go vote on election day. And while he was walking up on the sidewalk, this car driver drove up after the politician and tried to, scare him, is what he said he was doing, and luckily missed the politician, and then they caught the driver. And he said, "I was just trying to scare him. I don't like the guy." Well, basically, you've attempted murder. It's an incomplete crime. He might say, "I was intending to scare the person," but you could have killed him. So it's an attempt, and the person wasn't successful at it. That's all you need to do is try. In this case, and still going to be charged with the crime of most likely it would have been attempted murder there. Okay. Another inchoate or incomplete crime is. And I keep saying incomplete. Obviously, it's complete in the sense that the person's likely to get convicted if it can be proven in a court of law. But it's incomplete in the sense that they didn't get completely what they were trying to get with their intent. Okay. So here, another inchoate crime is aiding and abetting. So somehow you persuade someone, you assist them, maybe even inadvertently in committing another crime. You tell somebody, "Gosh, that person said something bad about you over there. Go get them." You shouldn't put up with that. You're inciting them or pushing them towards doing this. So here's an example. You pressure a friend to get even with somebody else by harming that person. Another way that this happens often is, someone, a friend or a sibling or someone else commits a crime. They come to you and say, "I committed this crime. It's terrible, and I just don't want to get caught by the police. And so, will you hide me in your attic or basement for a while?" Well, you don't want your friend or sibling maybe to face that penalty, but guess what? When you do that, you've committed the inchoate crime of aiding and abetting. You're assisting that person, and you're protecting them from criminal punishment, and so you can be liable for crime as well in that case. All right, now we get to defenses, and in this case, with defenses, one of the significant ones in criminal cases, often someone might assert as a defendant, they say, "Well, I felt threatened myself, so I defended myself in this situation." And so, if again, this is a jury's going to listen to this, if it's a reasonable person would feel that under these circumstances that there was some immediate danger to them, they have a right to defend themselves. Then under Old English common law and our system of justice, criminal justice, you will be allowed to do that. There's a significant issue here, though. In this case here, you have a woman who's trying to get into her car. A guy comes up from behind, or a person comes up from behind her and covers her mouth, puts a knife to her neck. Is it reasonable for her to think that she's in danger? And obviously it is. So can she defend herself? Yes. And if she does, and he gets hurt or killed, the key thing here, if he gets killed, here's someone spraying mace, is that deadly force can only be used in response to deadly force. So if this person has a gun and she has, say, a concealed weapons permit, she can get her car door open and she can pull out a gun to get him, or something else that's a deadly weapon to stop him. Deadly force is okay in response to deadly force. So if he just held her arm, can she reach in and get a gun and kill him? Boy, it'll depend entirely on the facts, and depends on what's presented before the jury. If she had a reasonable fear, and she could assert that she had a reasonable fear that her life was in danger, yes, she can use deadly force. But typically, someone has a knife to your neck, someone has a gun to your head. Do you have a right to use deadly force to defend yourself? Absolutely. That's the common law rule is deadly force can only be used against deadly force. So, for example, the person comes up and has a knife to her neck, and then she opens her car door, and and he sees that there's a gun inside the car. Well, he takes off running because he doesn't have a gun. He takes off running, and she gets in the car, opens the door and grabs her gun that she's got a concealed weapons permit for, and as he's running away, pop, 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 she shoots him and kills him. Is that okay? Or, is self-defense allowed in that case? Or here's the other example. He takes off running again, and she has a pit bull in the car. And she's like, opens the door, go get him, Rex. And the dog goes and chews him up and kills him or injures him severely. Third example. He takes off running because he sees the gun or whatever, and she gets in the car, starts up the car, and chases him down and runs him down with the car. Is it okay now? In all three of those cases, once the attacker, even though they've committed a crime against you, by physical contact or threat, they've committed assault and battery at the very least. As soon as the attacker, and I abbreviated that as A, as soon as the attacker takes off, it's okay to pursue in the sense that you can chase after them to report to the police this person did this, and you're calling on your cell phone while you're driving, whatever, you have hopefully hands free, but you're driving and you're saying this person just tried to attack me, I'm following them, they're on such and such a street. That's very different from pursuing them and kicking them, harming them, shooting them, sending your dog after them, or running them down with your car. When the attacker retreats, you have just become the attacker if you chase them down and do harm to them. Sounds very odd, but you can't flip roles. Who's supposed to do that? Chase that person down and harm them if something happens? It would be the police. So deadly force is only to be used against deadly force. Otherwise, you need, again, self-defense. Typically, the basic rule is that you defend yourself, and it's lawful that you defend yourself when you have reasonable fear of harm being made against you. Who determines whether you had a reasonable fear of harm? That's going to be the jury, ultimately. Okay. All right. Another defense to crimes is what's called duress, and this is okay, or it's allowed under the courts in every type of case out there. Not every type of case, but many cases out there, except for when you've killed someone. If you're the defendant and you killed someone, you can't say you can use the duress defense. Basically, what you're saying in this situation is you felt, as the defendant, you felt somehow so threatened, or there's some imposing harm that could come your way that it didn't allow you to have proper judgment. You didn't have free will or free choice in this type of situation. A clear case would be someone puts a gun to your best friend's head and says, go in and rob that 7-Eleven or I'll kill your friend. And so you go in and you rob the 7-Eleven on behalf of this bad person. Well, you could say you're under duress, you felt some significant harm, even if it wasn't going to happen to you, it was going to happen to your best friend, and so you didn't feel like you had free will. You had to go in and rob this store, or you were going to be, your friend was going to be killed. So in that case, do you have a defense of the crime of robbing the store? You do. It still was a crime, but again, it would be up to the jury to believe whether it was reasonable that you felt you had a danger of harm against you. Now, a real case I worked on at one point many years ago, I won't name names or anything, I can't do that, but picture a person who is a world-class athlete. She's a runner, and she, has done this and won all over the world. She's done very good, done a good job at this, and she is in her off season. She's works on a construction site. And so she's, when she works at these construction sites, she's the person with the stop and slow sign that she turns. And this gigantic cement mixer, gigantic truck comes up and is waiting while she's got the stop sign held up because something's going on at this work site. She has to stop the cement mixer from coming in. And the cement mixer driver gets a little upset and, after a while is very impatient, steps on the gas, hits her and sends her 75 feet in the air, breaks both of her legs, and she'll never be the world-class runner she was again. So clearly in tort, she's entitled to money damages for her injuries, her medical bills, her lost wages, her pain and suffering, all that. But we're looking at the crime side of that. And the driver says, he makes one claim of the defendant makes a claim of duress to this charge of crime, being criminally negligent and essentially attempted murder with a gigantic truck. And he says, I was under duress. and he says, well, gosh, I have to be at all these different sites. I'm going to lose my job, and I have to be at all these different work sites for the same construction company that he worked with as the woman he hit. He said, I have to be at these spots or I'm going to lose my job. There's so many time slots. I've got to pour the cement, or the cement all turns bad in the back of my truck. She's holding me up for an unreasonable period of time, and so I was under duress. And so what do you think the court said? The court said, I don't think so. We often kind of joke and call this the devil made me do it defense. It's not a joke, I suppose, but someone else basically has deprived you of your free will. That's the argument. In that case, he definitely did not. Not only did he lose on the tort side, but he lost on the criminal side as well. Duress did not fly as a defense in that case. Okay. Another one, which I actually had trouble with this in law school on a certain level, when we're talking about this in criminal law, it's this idea of an insanity defense. Because to me, I think, isn't everybody insane when they commit a crime? When you do something, whether it's murder or it's you burglarize someone, whatever, rob someone, you have to be insane somehow. It's almost crazy that we should do such a thing. Even temporarily, you would think that I don't know. To me, it just seemed sort of like an oxymoron. Well, of course you're insane. You committed a crime, but the insanity defense in the jurisdictions where it's allowed, and I believe this the McNaughton case is where this started. I believe it started in this country with this McNaughton case in New York. But basically, what you're saying is the person's not guilty by reason of insanity. They're not guilty, and what you need in this for this to take place procedurally is there's a separate trial altogether, and the jury basically has to determine. And unlike a typical criminal case, I probably should have said this at the very beginning of the criminal law lectures here. Remember, the burden of proof in a criminal case is beyond a reasonable doubt. The jury has to believe without any question. If they have even the slightest doubt that the defendant did such a thing, then they can't convict. They have to acquit that person and let them free. Or they can't be convicted of the more serious crime. They could be convicted of a lesser crime. But if they have any doubt, they have to not convict, right? Beyond a reasonable doubt is the criminal standard. In an insanity defense type of situation, what is done is you have a separate trial altogether just for the mental capacity of the defendant. And so basically, by a preponderance, which is the civil standard in civil cases, a little more likely than not, you have to believe that the defendant was insane. So the defendant basically had to be unable to know or understand what they were even doing was wrongful. They didn't understand the act. They didn't know right from wrong, or they didn't know the act that they were committing was criminal. So now, interestingly, so you may be familiar with, there was a few years back, I think it was in, where was it? Not the Pacific Center, it was Westlake Center, I think, downtown. There was a guy who was out there with a full blade metal samurai sword, and he was screaming and yelling, and when the police would try to get close to him, he would sway and move this thing all around in the air. And the claim here, I mean, obviously he put a lot of people at risk of their lives, but the claim was he had an insanity defense, and so did he know that even the nature of what he was doing was wrong? Could he tell right from wrong? And clearly there was a mental illness that was there, and that could be established. And so again, it's interesting if you look at the cases that. And this doesn't mean the person is set free. More often, as it's turned out in practice, people where the insanity defense is granted as a defense for the defendant, in those cases, people actually spend more time in a mental institution than if they had actually gone to prison for the crime that they would have committed. There's some statistics to show that. So. All right, we're on the last slide here now, and I'll just put all these up here. The Constitution is, because, again, our constitutional system is aimed at primarily it's about the word power, and it's about someone being able to misuse power ultimately and protect us from the power of the king is a lot of what our Bill of Rights was all about. When you look at criminal law, we're in that same way of thinking. It's trying to prohibits the king, government, from being able to step in and do whatever they want whenever it wants. And so the Fourth Amendment, as you know, is about illegal searches and seizures, and so trying to prevent government from just showing up without a warrant, or just showing up as the king would do, is just send troops into someone's home and have no idea whether they did anything wrong, but they found something wrong in the house, and they would arrest those people, and that was it. So Fourth Amendment was to prohibit against illegal searches and seizures. That happens now in modern times. We have issues about those things at someone's home. It may also be that we have those issues with someone in a car or a telephone booth. Did they have a reasonable expectation of privacy? It's very different in your home from, say, in a telephone booth. And so illegal searches and seizures, there's a lot of case law on those types of cases. Fifth Amendment, as you know, is about fair trials and due process of law, and also the prohibition against having to incriminate yourself, to basically say something that causes you to be a witness against yourself. That's our Miranda rights, and the Fifth Amendment is aimed at trying to, in that case, with Miranda types of cases, you're given your rights and told you have a right to remain silent, and so you have a right to meet with a lawyer to talk about your case before you say anything and make a statement to police in that case, right? Sixth Amendment, you have a right to a speedy trial, and that's, again, so that the king wouldn't keep you locked up forever, without a trial taking place, and so that has criminal law ramifications. Seventh Amendment entitles you to a jury trial, and so you don't have just the king or the king's representative, one judge, making the decision, although you could ask for that. You're entitled to a jury of your peers, is what they say, and so you're entitled to have an actual court trial with a jury to hear your case and confront your accusers in that process. The Eighth Amendment is prohibiting, as you know, cruel and unusual punishment. And all those, Fourth through the Eighth Amendment specifically, aim towards protecting our fundamental rights, and they have ramifications, all of them, in our criminal law. So hope that is all informative for you, and that's the end of part 2 of our criminal law discussion, and I hope I hope you enjoyed it. Thank you.